The motion be agreed to.
Mr Speaker.
Charles Chauvel.
Thank you, Mr Speaker. Mr Speaker, we are where we are in respect of this bill. I am somewhat disappointed, despite the attempt of the Attorney-General just now to reach a degree of graciousness, that he couldn't have simply picked up the phone and sought a bit of cross-party consensus on the legislation itself. It was very difficult to get a copy of the original bill that was considered by the House in first readings, to analyse the changes that had occurred between the publication of a consultation draft and the introduction of the legislation. Nonetheless, as I said in my earlier speech, I'm very pleased that Labour, working on this occasion with the ACT Party, was able to force the Attorney into agreeing to a select committee process. It would have been completely unacceptable if this legislation had not at least had some public input into it, and it is pleasing that it was possible to override his instincts against the rule of law and standing orders on that count. It is incumbent, I think, on me to thank the Office of the Clerk for the drafting assistance that I had from them, and in particular from Tim Workman. We've heard a reference to a hodgepodge solution concerning warrants that was never going to fly. Well, the Office of the Clerk and I did our best to do the Attorney-General's job for him on that point. Unfortunately, he's right. In the time available to the House, and this is not a matter that should be taken pleasure in by anybody, but a matter for regret, it wasn't possible to put proper controls in around the sort of powers the police ought to have. And what that does is tell us all that it is absolutely a matter of priority that the next Parliament should pass the search and surveillance bill so that enforcement agencies have clear powers and also clear controls on those powers. And as I have said previously, it is a terrible indictment on members opposite that legislation has languished on the order paper for a year in the face of a bipartisan offer of support, because those members have preferred to pursue window dressing options in the law and order and justice sphere rather than get on and protect New Zealanders in the way that they ought to. Having said those necessary preliminary words, sir, I do want to turn to one or two things that were said in the committee stages of the debate. And I think the first thing that I am bound to address is the contentions by Mr Locke, a member for whom I have great respect, that the Labour Party and the National Party simply have the same position on the lawfulness of trespass, search and surveillance. And I have to say to Mr Locke, that suggestion is beneath him. He knows that it's not right, and he knows it's not right because the Labour Party set out in the minority report what our position on trespass, search and surveillance was, because it wasn't clear as to the lawfulness or otherwise of such surveillance. We said there has been much discussion about whether covert video camera surveillance is lawful. Labour members think the fairest summary of the position is that while it had generally been considered permissible, an influential body of opinion had been growing prior to the Hamed decision that covert video camera surveillance had an unsatisfactory legal footing. This is because in many cases it was not positively authorised by any statute or rule of law. It was simply not prohibited. This view is reinforced by the Law Commission report and its call for a statutory basis for the activity, which we hope will be provided as soon as possible with the prompt passage in acceptable form of the Search and Surveillance Bill. Now, that's very clearly and on the record the Labour Party's position on this matter. We heard David Parker earlier describe the evidence that was heard at the Select Committee as to why some form of temporary fix was required in the interests of justice in order to go forward. He referred to the position where some quite serious offending around the drug dealing activities of organised crime has to be dealt with by trespass video surveillance, despite Mr Locke's contention. and that is very sophisticated criminals have got into the habit of not using telephones or talking to one another about what they're doing. They write what they are doing and what needs to be done on whiteboards for one another, and that is how they communicate messages. Well, I guess they do that with the curtains drawn, Mr. Locke, which is why there is, I agree with you, sir, not a wide case, but a case nonetheless subject to Section 21 and subject to Section 30 for some of this type of activity to be required in rare cases. And that is why the Labour Party has taken what we think is the responsible position. Don't prohibit it outright, don't leave a legal lacuna, lend some credibility and some legal authority to activity in the most serious cases and try to put checks and balances in while restricting the whole temporary fix to 6 months. And I'm very satisfied that that is the responsible position to have taken. I just want to say one other word on the speeches that we heard in the committee stages. I listened carefully, as I always do, to Rahui Kātane, and I was embarrassed to hear her speech because she was speaking quite clearly on an earlier draft of the bill, not the bill that's come back to the Select Committee. And if she actually read the bill, and she is legally trained, she would realise that significant changes have been made to it that answer the criticisms that she dealt with in her speech. And again, Hone Harawira, somebody for whom I have a lot of respect, just got it wrong in his speech. He said, for example, that the lawyers had all come along and made these criticisms of the bill. Well, what he needs to realise is that the Law Society and, for example, Mr Knight, have both said that the changes that the Select Committee made to the legislation are very positive and actually satisfy most of the concerns that were raised. Let's just remember that those changes were made at the behest of the Select Committee and in the face of what would have been opposition to a Select Committee process by Christopher Finlayson. My two final words are these. It is quite right that this activity is disrespectful of the Supreme Court of New Zealand. This Parliament, in a future session, is going to have to address that issue. We have a Supreme Court now. We don't have judges in England to run to if we get things wrong. But we have to accept that a corollary of that is that, generally speaking, the law as it's declared by the Supreme Court is the law. It's not for us to pick and choose how the law should work. So we have to look at equipping the Supreme Court with appropriate powers for the exercise of its authority. In Canada, for example, the Supreme Court can declare the law to be a certain way, and then it can suspend the law for a certain period of time to allow the executive or the legislature to bring the necessary legal technicalities into line. We've never given the Supreme Court that particular express authority. I personally believe it has that authority at common law, and I'm sad that the attorney isn't willing to send Crown lawyers over the road into the Supreme Court to ask them to exercise authority in that way because he's concerned about what other parts of Pandora's box he might open. But if we're not to invite the Supreme Court to find inherent jurisdiction to be more flexible about the way it applies remedies, then we have to legislate to give it those powers. And my final word is this, sir. It has to be time for us to think about entrenching the New Zealand Bill of Rights Act. We can't continue to go through these exercises that just discredit the way in which the rule of law is respected in New Zealand. And certainly, for my part and the part of my colleagues on this side of the House, we're very clear that that needs to be very firmly on the legislative agenda.
Before I call the next member, I wish to correct the record. The votes on the amendment in the name of Keith Locke and on the provisions of the Video Camera Surveillance Temporary Measures Bill stand in part was incorrectly announced as ayes 115, noes 105 and ayes 105 and noes 15 respectively. The correct results on the Locke amendment, ayes 14, noes 105, and on the main question, ayes 105, noes 14. The record will be corrected in both cases.
Thank you, Mr. Speaker.